Okay, so I want to do a deeper dive for my subscribers on the Runkel v. Tate class, or case, I should say, that is being litigated right now in the Northern District of California about the California's broad definition of what constitutes the licensed practice of psychology and how that interferes with most of what coaches do, no matter what kind of coach, life coach, health coach, wellness coach. You are presumably practicing psychology because the definition of psychology, according to California, is preventing, treating, and intervening to increase effective functioning of individuals, groups, and organizations. Increase effective functioning of people. That is what coaches do. That's why people hire coaches, is to increase their ability to function at optimal levels, at higher levels, whether it's in one of the multiple dimensions of wellness, spiritual, emotional, intellectual, social, physical, mental, all of those dimensions. Why we hire coaches is to help us increase our ability to function in those dimensions, increase to an optimal level, preferably. And this case that's been brought by the crappy childhood fairy, Anna Runkel, who isn't a licensed psychologist. She had her own experience of childhood trauma, learned some ways to deal with it, and decided to start a coaching business to help others who might have similar background. And she offers group coaching sessions, retreats, one-on-one coaching sessions. She does educational stuff. And she says that she doesn't treat any mental illness. She doesn't provide therapy. And yet, the California Psychology Licensing Board came after her and told her to stop because she wasn't licensed to practice psychology. And so now the lawyers who are representing is Runkel, and they are with the firm Pacific Legal Foundation. And I've actually tried to reach out to them to get them on my podcast. They are arguing that the statute that defines the practice of psychology in California, which is not an unusual statute, by the way, just because it's in California doesn't mean that other states have, they do have similar definitions for the practice of psychology, as well as medicine. The practice of medicine is another one of those practice areas that are defined very broadly, that makes it almost impossible to not do something that falls within the scope of practice of one of those licensed professions. If you're ever trying to give people advice in health or wellness, in how to reduce stress, all those things could conceivably be part of a licensed healthcare practice like medicine, psychology, and if you're talking about food, then also the practice of dietetics usually comes into play. And I think this is a really interesting lawsuit, not only because it impacts so many people, there are so many coaches out there, but I just recently wrote 2 law review articles on this very topic. And so the timing of this lawsuit, which again was filed June 3rd of 2026, is just really uncanny because I have 2 articles that are in publication right now. One called The First Amendment Free Speech Protection for Unlicensed Wellness Coaches, which will be published in FIU Law Review, hopefully later this year. And then the other article called Overbreadth of Medical Practice Acts is going to be published in Seton Hall Law Review, I think in early 2027. And they're related because the first one just talks about what coaches do, unlicensed wellness coaches do, which is what I would consider Anna Runkel to be, an unlicensed wellness coach. She calls herself a crappy childhood fairy, but what she's doing is unlicensed wellness coaching, always unlicensed. So it's really unnecessary for me to say unlicensed, but as a wellness coach, she's just talking. That's what she does. She talks to people about how to live better, and gives them some tips and tricks about how to live better in the space of childhood trauma, maybe. And then, and so the fact that what she does is primarily speech, my argument is in the law review article, and what the lawyers in this Runkel v. Tate case are arguing, is that it's mostly speech. And it should be protected speech. You shouldn't need a license to speak. States have traditionally regulated and licensed healthcare professions. And the reason for that, of course, is for patient safety. But the courts over the years have said that it's okay for states to regulate conduct, but they should not be regulating speech, because there is such a thing as listeners' rights. So the people who are receiving the messages from these unlicensed persons have a right to hear what they have to say. And so that leads to this whole concept of what the courts call the marketplace of ideas. And it's very important for, especially this current court, the U.S. Supreme Court, in its current composition, is very interested in preserving this marketplace of ideas where people share information. And yes, it can be very confusing for consumers about what to believe and what not to believe, but it doesn't, just because it may get confusing, the court does not view its role or the role of government to filter that information. There's only very specific, narrow categories of speech that is not allowed. Things like we can't yell fire in a theater, for example, and racial slurs, for example, could be prohibited. But for the most part, most speech is permitted under the First Amendment of the United States Constitution, including the speech that a wellness coach, a lifestyle coach, would say to a paying client. You can't, another category is you can't provide false or misleading information. That's illegal under the Federal Trade Commission Act. You can't intentionally mislead someone or misrepresent the facts. You can get in trouble for that. But if what you're saying is your opinion based on your knowledge and your experience, you shouldn't have to have a license to do that. Now, again, the courts have said states are free to regulate conduct. You can regulate what a person does if they're going to hold themselves out as a physician or as a psychologist and try to treat them with procedures. That would be, first, false and misleading communication, and two, it could be categorized as conduct, especially things like surgery and actually doing procedures on people would not be speech. But if what you're doing is talking to them about your opinions and your experience, and they value that enough to pay you, then I think the Supreme Court in particular in the U.S., will be very amenable to that kind of speech. And I think regardless of what happens at the lower court level with this Runkel v. Tate case, if Anna Runkel loses at the district court level, I think that there's been enough case law accumulating with other types of professionals who have been targeted by licensing boards that a higher court, like a court of appeals, and maybe even the U.S. Supreme Court might take the case, maybe not. But I think there's a really good chance of saying that Anna Runkel and people like her, who coaches, can do what they're doing without a license. And the other law review article that I wrote recently, Overbrush of Medical Practice Acts, this isn't directly relevant to the practice of psychology, but similar. The practice of psychology is defined by California and many other states as very broad. And that is also true for the definition of what constitutes the practice of medicine. And about 16 states include in the practice of medicine the prevention of disease. So my law review article really zeroes in on that piece of the practice of medicine as including the prevention of disease, and highlights that in those states where the definition of medical practice includes disease prevention, basically what those states are saying is only physicians can prevent disease. No one else. If you are engaging in discussions about preventing disease, about how you can prevent diabetes or high blood pressure or cardiac events or some other illness or disease by what you eat, by physical activity, by what sleep schedules, all the different things that go into, exacerbating the potential for disease. You wouldn't be able to do that according to these states because that is constituting the practice of medicine. And if you don't have a license to practice medicine, you shouldn't be engaging in those activities. And I say that's too broad, just like the practice of psychology is defined too broadly, according to the lawyers in the Runkel case. And it creates confusion for people who want to coach and help prevent disease, who want to help people improve their functioning. And how do you know what you're saying is safe or not safe? And if you have a law that produces that kind of confusion and uncertainty, that means it's probably too vague and too broadly worded. It needs to be pulled back to allow for the marketplace of ideas to flourish. And so I am really excited about lawyers bring the Pacific Legal Foundation taking a case on in California. And again, I hope I can interview them, the lawyers, one or both of them, for my Wellness Law podcast. But I think it's going to be fascinating to watch. And of course, as things develop in that case, I'll be posting videos and articles about it. Just wanted to share my thoughts and give you the little deep dive behind that case.